At a restaurant at Disney Springs served her food that ended up killing her.
But Disney is claiming the $50,000 lawsuit should be moved out of the courts because Piccolo agreed to arbitrate all disputes with the company when he first signed up for a 1-month trial. Disney is evil, bro.
Disney Plus.
What do you get when you have a multi-billion-dollar company that has covered themselves at every angle legally speaking, and they will not let you put an end to their uprising? Well, you get the story that I just recently found out today. Something absolutely ludicrous. Disney wants NYU doctors' alleged debt suit tossed due to a minor stipulation in a Disney Plus video streaming contract. What, dude? Let's jump into the story. I'm your boy Peablar, bringing it to you. Welcome to Peablar TV 2. Let's jump right in. So we got this article that we're gonna read today. Essentially, what happened is an NYU doctor and her partner both went to Disneyland, and something was consumed that was an allergen to this doctor. They asked numerous times to make sure that it was safe for consumption. The woman unfortunately did wind up passing away, and a lawsuit has been brought up against Disney. However, they claim that her partner created a Disney Plus subscription years prior and has forfeited any right to create a lawsuit due to an arbitration clause in the terms of service for Disney Plus. Like, how are these things even freaking related, bro? Let's jump into this article and see what's really going down. And then later on, we're gonna read the terms of service as well, to just see how Disney has covered themselves. So buckle up, buddy boy. Let's jump right in. So right off the top, we got an article from Emily Craig. Disney wants NYU doctors' alleged death suit tossed because of widower's Disney Plus subscription. Absolutely ridiculous. Disney is trying to get a wrongful death lawsuit filed by a New York University doctor's grieving husband tossed because he signed up for Disney Plus streaming service years earlier, court papers say. Kanakaporn, is that really this? Okay. Kanakaporn Tang Suan's bereaved widow, Jeffrey Piccolo, is suing the theme park juggernaut, claiming that she suffered a fatal allergic reaction shortly after eating at Disney Springs restaurant in Florida as of last October. But Disney is claiming the $50,000 lawsuit should be moved out of the courts because Piccolo agreed to arbitrate all disputes with the company when he first signed up for a 1-month trial. Just a trial, dude, for Disney Plus streaming services back in 2019. So this applies to everybody. I read the terms of service. If you have a Disney Plus account, you have forfeited your rights to any type of dispute inside that would require litigation. You need to handle any type of dispute, any type of disagreement with Disney directly, supposedly, through this arbitration clause, which is kind of ridiculous. Here's a picture of Tang Swan. Rest in peace. I'm not sure what she ate, to be quite honest. I don't know if it's listed, but let's move on. Piccolo's attorneys have slammed Disney's latest motion as preposterous and outrageously unreasonable. Like, literally, bro. In the May 31st motion filed in Orange County, Florida Circuit Court, Disney argued that the Disney Plus subscription agreement Piccolo signed years earlier on his PlayStation called for any dispute, with the exception of small claims, to be resolved by individual binding arbitration. The company added that Piccolo agreed to similar language when he then used the My Disney Experience app to buy tickets to visit the theme park in last September of that year, a month before the ill-fated trip. Disney has argued that both agreements require Piccolo to consent to the arbitration language before purchasing, the court filing claims. Piccolo's lawyers have since fired back, insisting in an August 2nd motion that Disney's arguments are fatally flawed. The notion that the term agreement by the consumers when creating a Disney Plus free trial account would forever bar the consumer from the right to a jury trial in any dispute with any Disney affiliate or subsidiary is so outrageously unreasonable and unfair as to shock the judicial conscience, and this court should not enforce such an agreement, the lawyers wrote. It is kind of ridiculous. It's like, hey, you're gonna sign up for our Disney streaming platform? That means that if you ever come to any of our theme parks or have any type of problem with any type of our media or anything along those lines, you are forfeiting your rights. It's like an NDA almost. You know what I mean? It's giving that vibe. vibe. It's very odd. We're good from any type of legal action because everybody's got a Disney Plus account. Like, dude, what? They also argue that Piccolo filed the wrongful death suit as a personal representative of the estate of Tang Swan and not on behalf of himself. Tang Swan, 42 years old, died of a severe allergic reaction known as anaphylaxis, just hours after dining at the Raglan Road Irish pub and restaurant with her husband back on October 5th, the original complaint said. The physician who worked at the Manhattan NYU hospital had repeatedly stressed to waitstaff that she had a nut and dairy allergy when she ordered scallops, onion rings, broccoli, and corn fritters, according to the filing. Soon after leaving the restaurant, Tang Swan started experiencing difficulty breathing and collapsed, court papers say. Even though an EpiPen was immediately administered to her, she did unfortunately pass at a local hospital later on. Piccolo is seeking more than $50,000 in damages under Florida's Wrongful Death Act, in addition to mental pain and suffering, loss of income, and funeral expenses. The Post reached out to Disney and Piccolo's attorney for comment, but apparently they did not get back to them. So that is wild, dude. Only $50K as well. Like, it seems very low, and I'm surprised that Disney isn't just, like, you know, handling the situation or, you know, just paying him out. It's a very low thing for somebody to die in your park. And I wonder what kind of damage this is going to do to Disney's reputation. Not saying it's sparkly clean right now, but this is definitely going to be another black mark on their history. Like, they chose to fight in court due to this arbitration clause instead of just paying the man out for his wife's death. Like, what, bro? So I guess we'll watch this real quick. Let's see what they got to say in this quick video here.
A man is suing Disney after his wife died following a meal. He claims that a restaurant at Disney Springs served her food that ended up killing her. The couple ate at the Raglan Road Irish pub last October. Now, according to this lawsuit, the waiter said the food would be allergy-free because the couple was concerned with severe dairy and nut allergies. Well, after dinner, the woman collapsed and later died at a hospital. A medical exam found that she died from an allergic reaction and she had high amounts of dairy and nuts in her system. An attorney that specializes in these kinds of cases has some advice to help keep businesses and customers safe.
Consumers, tell your restaurants up front, your ice cream shops up front about your sensitivities, and restaurants and ice cream shops, train your employees and just wash your implements. Do the little things that will create a better customer experience.
All right, we only got like 10 seconds left of this clip. First off, nothing against this lawyer. He looks like he's on crack. Secondly, you know, I don't know who's really to blame in this situation. I'm sure that the chefs in the kitchen probably did wind up trying to, you know, keep everything separated and make sure that her meals are right. There's no real reason for the waitstaff to spike her food with dairy and nuts. However, you gotta take these things seriously, especially considering how intense your allergies may be. There's probably cross-contamination all over the kitchen. So even though they may not have put dairy or nuts directly into the food, it's probably all over the utensils and the pots and the pans and just everywhere. So let's see what else they gotta say.
That man, by the way, is suing for at least $50,000, which is a standard number to determine which court will hear the case. We are waiting to hear back from Disney and the restaurant regarding that.
All right, so that's a standard number. So my man may get a little bit more than 50. I think he needs more, dude. I don't know, that sounds crazy. 50 grand? Do you know how much a funeral is? Like, genuinely, I feel like that's like half the price right there. Like a casket's $10,000. Sorry, I don't know. That seemed really harsh. I'm just saying, dude. The man needs more money. But I got the terms of service right over here. So let's jump in and read them out because apparently, you know, I don't directly have an account, but somebody in my household does have a Disney Plus account. So they have forfeited their rights over. It's done. And if you apparently book a Disney trip using the Disney Magical Experience app, you're screwing yourself over legally, apparently. But let's see. So right here we have disneyplus.com, the Disney terms of service, guys. And if you scroll right down, I thought I was gonna have to dig for this. It's, you know, it is a large thing, but they have it right at the top here for you. Please read these terms and any specific and or supplemental terms and conditions carefully before using the Disney products. These terms govern your use of Disney products products in general. Umbrella statement. By using the Disney products, you agree to be bound by these terms and any specific and or supplemental terms and conditions. Any dispute between you and us, except disputes resolved in small claims courts and related to the ownership or enforcement of intellectual property rights, are subject to a class action waiver and must be resolved by individually binding arbitration. Please read the arbitration provision in section 8 below, as it affects your rights under this contract. So let's jump to the section 8 arbitration clause. Let's see what we got. I just clicked on the section 8 thing and it's just making me sign up here. That's not what I clicked on, bruh. Section 8. Dude, their freaking app's broken, bro. Lawsuit. I can't read the arbitration clause. All right, let's see here. Number 8, binding arbitration and class. Dude, you literally cannot read it. Did they like brick the website because this story is developing? Whatever, we'll scroll down. I don't give a flip, Disney. Boom, we're rolling. Number 5. Number 8, binding arbitration and class action waiver. Please read this provision carefully. You are agreeing to resolve all disputes between you and Disney through binding individual arbitration and include a class action waiver and jury trial waiver. You and Disney agree to resolve by binding individual arbitration as provided below. All disputes, including any related disputes involving Walt Disney Company, its subsidiaries, and its affiliates, except for any claim within the jurisdiction of small claims courts consistent of the jurisdictional and dollar limits that may apply, as long as it is an individual dispute and not a class action lawsuit. And 2, any dispute related to the ownership and enforcement of intellectual property rights. Disputes include any claim, dispute, action, or other controversy, whether based on past, present, or future events, whether based in contract, tort, statute, or common law between you and Disney concerning the Disney products of or this agreement, or this exclusive authority to resolve any dispute related to the interpretation, applicability, and enforcement of these terms, or the formation of this contract, including without limitation the arbitration. There's like a lot of points here, but it seems to just be saying the same thing over and over. It's just like the stipulations. So yeah, that's pretty much it, guys. What do you think of this situation? Do you think Disney is evil, bro? Like, I feel like it's becoming more and more apparent that Disney is a soulless company. Like, what have they become, dude? Or were they ever really better? That is the question for today. I hope my man wins this case. I hope that their arbitration clause gets removed. Apparently, it is a legal thing in America to have arbitration clauses. It kind of seems like real sketchy to me though. It seems like an NDA form, which those I heard are getting into some turmoil and may be thrown out and may not hold any real legal consequences if you were to break them. But it just seems real sketchy that a company can just have an umbrella statement like this to protect them and their properties. All of them. But comment down below what you think. Yeah, I don't know. Comment down below your favorite Disney product. I don't freaking know, dude. I post 3 times a week, so if you like this type of content, definitely consider joining the Peablar Army. Make it a part of your weekly schedule. Weird and wacky internet stories. Sometimes they get crazy, sometimes they'll make you laugh. No promises out here, okay? As for me, I am your boy Peablar, guys. It's been real, and until next time, be well and peace.